Hello and welcome to Talking Points. I'm Dave Kelly, Director of Advanced Media Production at Cal State Long Beach. Today we're going to talk about the Supreme Court and the separation of powers between state and federal courts. Legal scholars refer to this separation as dual sovereignty or separate sovereignty. My guest today is Dr. Kevin Johnson. Dr. Johnson is the Director of the Center for First Amendment Studies. Welcome, Kevin, and thank you for what is now your third visit to Talking Points.
Thank you for having me again. I really like the crew and everybody involved, and thank you for having me here.
Well, we're glad to have you. So before we get into the main topic of the day, which is the dual sovereignty and the separation of powers between state and federal courts, I want to first go over the current state of the Supreme Court as it exists today. As we know, there was a rancorous and contentious confirmation fight for the most recent Justice, Brett Kavanaugh. And during that confirmation hearing, the first couple of days were disrupted loudly by activist groups from the left. And then once they got the chaos under control, the hearing proceeded. But at the very end of the hearing, there were last-minute allegations levied against Brett Kavanaugh of sexual assault, which had occurred 36 years ago. These allegations were investigated ultimately by the FBI. They were unable to corroborate or verify any of those allegations. And as such, Brett Kavanaugh was confirmed by the Senate by a very thin margin of 2 votes, and only 1 vote from the Democratic Party, and that was Senator Joe Manchin from West Virginia. So with all of that said, give us some historical context here about how we arrived at this point of such a contentious Supreme Court hearing, and why were both sides of the aisle so angry with the proceedings?
So there's a lot of issues to unpack with the hearing, but the things that I think are happening here is that there's 2 competing narratives. One narrative thinks about the confirmation hearing as a political strategy, about winning and losing and the tactics that are involved in politics. That particular strategy dates back to a lot of the election theory and philosophy that we've had throughout the history of Western civilization. Quintus Cicero, for example, documented how to win an election and said that one of the tactics to win an election is to accuse your opponent or other potential opponents of sexual scandal and corruption. And so from this particular narrative, the idea that sexual abuse and sexual misconduct and sexual assault would be used as a political tactic is perfectly within that particular type of narrative. The competing narrative to that is one of sexual assault victims being silenced and not being taken seriously as a matter of political spheres, legal spheres, political spheres, cultural spheres, etc., and that the word of men often wins out over the word of women when women are disproportionately affected by sex crimes. And so when you've got these 2 competing narratives, they provide this kind of powder keg moment where people who view it as a political tactic are upset and resentful that they're just bringing this up, when people who view it as a history of sex discrimination and sex assault, they're much more prone to not believe that it's just a tactic. The reality is that it could be both, but this is the competing dominant frame. That's on the one hand. On the other hand, we've got this history of the Supreme Court confirmation hearings that has proliferated in terms of the amount of time and contentiousness that these hearings have taken place. This first happened when Bork was nominated to the bench. And prior to that, I think the nomination process only took like 10 hours, maybe, of questioning from senators. And I believe the Bork hearings took 40 hours. The Republicans were really upset about that. And I think that since then, the average has increased and increased over time, and then the politicization of that nominee has become more and more. Whereas prior to Bork, it was just the president's kind of nominee, so long as they were a judge and so forth. Before, they would continue to be a judge on the Supreme Court, and they were kind of passed. So we've escalated to Merrick Garland, and then now to Brett Kavanaugh, and now we've got all of these competing narratives in this kind of powder keg political moment in American politics.
And it does seem that every time there's another escalation, as you mentioned, with Merrick Garland, he was denied even a hearing, which certainly would have been humiliating and frustrating for him, and certainly frustrating for the Democratic Party partisans. And then when we get to Brett Kavanaugh, it escalates to the point of character assassination, as you've just been describing, as a political tactic. And so we've seen that escalation continue, which leads to my next question, which is, given the highly polarized political environment that we have today, and with the Kavanaugh hearings noted, does that mean that if, in the event that President Trump has the opportunity to appoint another Supreme Court justice, which would be his third, are we going to see a similarly rough and tough political fight?
It could be. The rationale, remember, for Merrick Garland was that it was happening during an election year. If this new nominee comes about in November or so, like the Merrick Garland, I believe that was around the time frame, if my memory serves me correctly, and it takes over a year to actually have a new justice replace that seat, then I think maybe the Democrats will be like, well, that was the case when, this was the argument that was advanced when Justice Scalia passed away. This is the same rationale that we're using with the new appointee. That could be one of the fights. I think it is important to note that the same kinds of fights haven't been fought on all grounds by all parties and so forth. For example, the Democrats didn't fight against Justice Gorsuch nearly as much as they fought against Brett Kavanaugh. They did not fight against Roberts as much as they fought against Justice Thomas, right? So you've got different types of fights that are levied at different particular moments, which then gives the people who are of the tactical slant narrative more evidence that this is a totally political thing, but then also provides evidence to the other narrative, which is to say, it's not everyone we're accusing of sexual assault. We are confirming other nominees, then you should believe us as well.
Okay, well, let's move along to the concept of the swing vote, because that's what everyone looks at, is the concept of who's going to swing the vote one way or the other. And in recent history, it seems that the swing vote has always resided with Ronald Reagan's nominees, at least until now. Sandra Day O'Connor, which was a Ronald Reagan appointee, was known as the swing vote in the late 90s, early 2000s. Right. And then that role seemed to shift, or if you want to say she passed the baton to Anthony Kennedy, who became the swing vote, or known as that, in the 2000s. Now that Anthony Kennedy has retired and we have his replacement in Brett Kavanaugh, the court watchers are telling us that basically it looks like Chief Justice John Roberts is evolving into the swing vote role. So let's talk about the swing vote. Is it what we assume it is, or is it not as cut and dried and simple as we've been told? I
don't think it's ever as cut and dry. I do think that on the one hand, it's important to note that the most common decision of the Supreme Court is a unanimous one, a 9-0. That's the most common judicial decision. So the swing vote is really relevant more so, I think, to legal practitioners that are trying to develop a strategy in arguing in front of the court. In other words, they're strategizing which justices are persuadable, which ones are more likely for me to craft my argument in a particular way to be able to get a decision in my favor. It may be that you're running up against a 9-0 decision and you already have probably a losing case, but the notion of a swing vote is one where you're looking for some sort of some sort of difference between a justice. Like if Justice Thomas and Justice Scalia disagree on the regulation of violent video games, for instance, you might be able to craft an argument that might get one of them to vote for you in that particular case. And so I don't know who will evolve as a swing vote. I think that it probably depends on particular cases and readings of that justice's arguments in the past and how those legal practitioners could then negotiate their strategy to get the majority rule in their favor.
Okay, and so with that notion of the swing vote not being as simple as we might think, it depends on the case law and the particular leaning of that justice in prior case law. Okay, well, let's move on to a particular case that is on the Supreme Court docket right now, and that's the case of the Bladensburg Peace Cross in Maryland. And this is a case that's being challenged by the American Humanist Association. Basically, the background is a large 40-foot tall cross was erected in 1925 to honor the war dead of World War I. It was paid for with private donations from families, from businesses, and the American Legion. And the American Humanist Association is now involved because the land where that cross sits is on a median on a busy highway in Maryland. And the Humanist Association says, well, this is an example of the state taking care of and promoting one religion over the other, because the cross obviously is a symbol of Christianity. The land in which that cross sits right now was taken over by a Maryland State Commission in 1961. So the state is literally the caretaker of that site. So how do you think, based on prior cases like this, how do you think this one's going to go?
Well, first off, I think that the busy highway means a little something different to you and me living in California. But it is on a little intersection, and it's a big cross. It's one that's very, very noticeable. I think that the Supreme Court has, and Justice Breyer has explained this reasoning pretty well. I think that the reason that he allows, for example, religious monuments to be outside of a courtroom that have been established for a long period of time, where nobody's really paying much attention for many, many years, but doesn't allow a judge to then, in the current moment, tack up the 10 Commandments on a wall. I think his reasoning is quite simply that that historically we're looking for what would work best for the entire community in a given case, right? I think for him, it's a pragmatic orientation. This is how he balances it. My guess is that because the cross has been there since at least the early 1900s, 1917, I think is what we said in the year, and 1961 is when it became a federal or a state-owned land. I think that because it's existed there for 50 years or so without any real controversy, I think the courts will take a look at those precedents and say that it's okay to still be there.
And just to reiterate,
but if they tried to build a new cross now, I don't think that would necessarily be okay.
Yeah, and I wanted to just reinforce what you said about Justice Breyer, because he did say in a comment related to this that history matters,
right,
which is exactly what you said.
Right.
And he also said that, however, we're a different country than we were back then.
Right.
This probably wouldn't be okay now, which is exactly what you just said.
Yeah.
So we're going to go to the break right now, and stay with us. When we come back from the break, we'll dive right into that concept of dual sovereignty and the separation of powers between state and federal courts. Stay tuned.
Do you love to travel? Understanding the world and all of its diverse cultures? Ever thought about becoming a foreign service officer? Living in another country and helping to promote a positive image of America? Or going undercover and working for the CIA? Or as a lobbyist, representing different interest groups to members of Congress? You can become a part of this exciting field with a degree from Cal State Long Beach.
Welcome back to Talking Points. I'm Dave Kelly, and my guest today is Dr. Kevin Johnson. And Kevin, before we went to the break, we talked about the Bladensburg Peace Cross in Maryland and what we think will be the likely outcome in that case. So we're going to move on now to some other cases that are on the Supreme Court docket this term, and those involve the concept of dual sovereignty and separate sovereignty and so forth that we talked about earlier. The first one I want to talk about involves a Native American by the name of Herrera, and the case is called Herrera versus Wyoming. And in this particular case, Herrera was arrested for hunting elk in Bighorn National Forest in Wyoming. And he is claiming in his appeal that this was inappropriate. His arrest and prosecution is inappropriate because, as a member of the Crow tribe, the Crow tribe apparently had a treaty with the federal government dating back to 1868, which allowed the Crow tribe to hunt on quote unquote the unoccupied lands of the United States. So that's where the case rests at the moment until the Supreme Court hears it. What about this notion of Native Americans having treaties with the United States that go back 100 or maybe even 200 years? How have the courts typically looked at those kinds of cases?
It's a very tricky area. I mean, the United States has gone back on a number of treaties throughout its history, so it's not got a very good track record of upholding the treaties. With the given case, what's interesting to me is I'm an avid camper, and one of the things that we know about is that there's a difference between national forests and national parks. Teddy Roosevelt was known as the conservation president because he was out there hunting one time, and he noticed that he would try to shoot one animal and take that animal and clean it and eat it and so forth. He noticed other hunters were not acting with the same practices, that they would shoot the whole herd and then take a couple animals from the herd. He believed that that practice wasn't sustainable, and so this is why he was a big advocate of the national forests, to be able to have restrictions on hunting so that we could preserve the populations of, in this case, elk, and other cases bison and other animals in these national forests. I think what's interesting is that the notion of the tribal sovereignty here seems to be consistent with the national forest conservation theme. It's not like Herrera, from my understanding, was hunting down a whole herd of elk.
No, it was sustainable hunting. It was to provide food for his family.
Right. So my guess is that that rather than undermining the whole national forest, they're not going to say Bighorn National Forest no longer exists. They're not likely to anyway. They'll probably reach some new interpretation of the treaty and the national forest and how the values of the treaty are reinforced with the hunting and how that's consistent with the national forest. They may rule in Herrera, or for Herrera in this particular case. The other note that I think is interesting is that it's Herrera versus Wyoming, and so there's also a separation of jurisdiction with the state being involved here in a federal national forest. So that's an interesting dynamic as well.
So we're actually talking about the possibility of three different sets of sovereignty here.
Right.
They're the Native American nations, which were called sovereign nations years past. And of course the federal court and the state court, as we mentioned with the state of Wyoming.
That's right.
Very good. So let's move on to another example of Native American involvement in Supreme Court cases. There is another case, and it's called Carpenter versus Murphy. Now this involves a man by the name of Patrick Murphy, who's a member of the Creek tribe in Oklahoma. He was convicted of murder for a murder that was committed in 1999 on what was a previously tribal land owned by the Creek tribe, which is also called the Muskogee tribe of Oklahoma. But he was found guilty of murder in the year 2000 in Oklahoma State Court. But he is appealing on the notion that this should not have been tried in state court. It should have been tried in federal court because Congress never took the necessary steps to dissolve the Muskogee or Creek tribal lands. And as a result, the 10th Circuit Court of Appeals actually agreed with him and said this needs to be looked at under that prism. And the state of Oklahoma, of course, is not happy with that ruling by the 10th Circuit, so they've appealed it to the Supreme Court, saying that there are about 3 million acres of land that would be considered part of the Muskogee tribal lands, including the city of Tulsa. So if we go back to what we thought of as Muskogee or Creek tribal lands from those years, what about all those other cases in the meantime? What do you think will happen here?
I don't think the Supreme Court is giving Tulsa away and making Tulsa no longer part of Oklahoma. So I have a hard time believing that the Supreme Court is likely to rule in favor of the 3 million acres. I do think that the 10th Circuit if I understand your synopsis well, it's that the 10th Circuit said this issue needs to be handled. And so in some way, it does appear that the treaty is still on the books. They didn't feel like there was enough precedent from the Supreme Court to effectively handle that question. So this is a way, I think, of ruling it to say that if the Supreme Court needs to really handle this question of how they're going to exercise state sovereignties, state boundaries for the state of Oklahoma, and these tribal boundaries, and how those things have been negotiated and practiced over the years.
And so basically it comes down to whether this should have been tried in federal court or in state court. It was tried in state court, obviously, back in 2000. And so it's not a question of guilt or innocence.
Right.
With Murphy, it's a question of what is the proper venue.
Right. And my guess is that the Supreme Court will say that the state courts have jurisdiction over the murder case. The history of the Supreme Court in many of these murder cases has been to allow for the convictions to stand. There's been notable exceptions to that, but I don't know that the Supreme Court's going to allow the person to not be found guilty because they're not on Oklahoma land.
Okay, and let's talk about more issues involving Native Americans and the Supreme Court. A lot of folks may pass by a casino on Native American tribal land or reservation and say, well, why are they allowed to build casinos on reservation land? And it goes back to the sovereign nations issues, and there was a famous case in the Supreme Court, which was actually California, state of California versus the Cabazon Band of Mission Indians. Cabazon Band of Mission Indians, it's a very small tribe located east of Palm Springs in the Coachella Valley, Indio area. They battled with state of California over the right to have gaming. They went to the Supreme Court and prevailed. The Supreme Court actually ruled in their favor that they could have gaming based on federal jurisdiction over such things. And so given that that's the case, the federal government seems to be the go-to place of choice or venue of choice for Native Americans in situations like this?
Yeah, and I think it's important to note that in many of these cases, many of the Native American tribes are basically arguing a question of jurisdiction on their own. Why is it that the federal government has the right to interpret a treaty when they're already sovereign, right? And so that's already begging the question of who gets to try these cases. Their argument would be we should be holding this on our land that is our land, and holding it in a Supreme Court is like holding it in a foreign government's court over an interterritorial battle, right? And so it's already kind of a strange question to posit that in the first place. I do think that in the case of gaming, if sovereignty means anything at all, it means the ability to exercise the decisions and that one would want for themselves. That it comes with it the degree of being sovereign and autonomous. And so, if they want to build casinos, they should probably be able to build casinos. If American government doesn't want its citizens to travel there, we have travel bans on all kinds of places of the world that we don't allow American citizens to go to. They could do the same thing there.
Okay, well, let's move on to another case. This one doesn't involve Native Americans, but it involves a case called Gamble versus the U.S. There's a man by the name of Terrence Gamble in Alabama who was charged with possessing a firearm after becoming a felon. Now, the federal government was accusing him of this and preparing to prosecute him for this, but Gamble is saying, no, I already served my time and was prosecuted by the state of Alabama for exactly the same crime, essentially. And so this is that dual sovereignty or separate sovereignty. Why can the federal government try someone for a case that was already adjudicated by the state court? What about that?
Well, you can be held guilty of both a state and federal felony, for example, right? Or a federal felony and a state crime. You can be guilty of the same crime twice because they're not the same crime.
What about the concept of double jeopardy?
Double jeopardy is about being tried for the same crime twice. it's not the same crime if they're different laws. One law is the federal law, the other law is the state law. Those are separate jurisdictions, separate different crimes based on two different parties that have been offended. One is saying the federal government's been offended, the state is saying that the state has been offended. Both are crimes to the different parties, and so it's not double jeopardy in that regard, I don't think.
Okay, let's move on to another case involving a similar dual sovereignty. Okay, this one is called Timms versus Indiana. This will be decided by the Supreme Court on this docket. Tyson Timms became an opioid addict and sold heroin to an undercover officer. At the time, he owned a Land Rover, which he purchased with $42,000 that he had acquired from his father's life insurance policy. So when he was arrested for the crime of selling heroin to an undercover officer, they took away and confiscated the Land Rover, which was worth $42,000. The problem is, in the state of Indiana, where this took place, the limit for confiscation and fines is $10,000. And so this is now in the Supreme Court, and actually, the Supreme Court actually ruled on it already, and by a 9-0 decision, they decided that, well, $42,000 is a bit excessive for a $10,000 limit.
Right.
So we only have about a minute left. What about that?
Well, I think it's important to note the unanimous decision again, going back to that swing vote question. But in addition, I think the court is probably going to go down a pragmatic test and say $42,000 is excessive, but the state still needs to be able to collect its $10,000. So if the Rover is the only thing that can be collected, they can auction it off and claim the $10,000, but the $32,000 balance is still the entitled property of the person that the property was seized from. So I think the court will take a test to allow for the penalty to be collected, but not necessarily excessively in that way.
Right, and I should note that in the decision, the 9-0 decision by the Supreme Court, it was noted that the Eighth Amendment does have a clause which prohibits excessive fines.
Right.
And so they cited that.
Yes.
Kevin, we've run out of time, unfortunately, as we always do in these conversations, but I want to thank you for being here today.
Yeah, thank you for having me.
And thank you for joining us on this edition of Talking Points. Be sure to join us again soon for the next episode. Until then, I'm Dave Kelly. Have a nice day.